first question coming from an attendee here regarding the mouse. I heard that the copyright for Mickey Mouse expired. Disney no longer owns the copyright. Is that correct? And does that mean I can freely use Mickey Mouse with my business?
Absolutely not. That is not true. The part that was covered in the news was not covered well, and this happens a lot with intellectual property. But anyway, let me explain what happened. So Disney actually, so they created this version of Mickey Mouse. Okay, and that's the version we're talking about. We're not talking about the modern version of Mickey Mouse that you see at the parks and everything else. We're talking about the version of Mickey Mouse that appeared in the cartoon Steamboat Willie. So it's that black and white, really rudimentary Mickey Mouse drawing from a long time ago. And the copyright for that lasted for a very, very long time. And a few years ago, actually, during the time that the Digital Millennium Copyright Act came out, Disney was successful in extending the life of copyright. So the duration of protection was extended through through Congress, congressional action. What you read, and clearly it has not been articulated very well, is that this particular version of the Mickey Mouse character, the drawing, the Steamboat Willie version, that is no longer protected by copyright. Everything within the last 95 to 120 years, that is still protected very much. And Disney will go after you. They go after a lot of people. But the Steamboat, if you want to use the Steamboat Willie cartoon, that is in the public domain. That is no longer subject to copyright. And the Steamboat Willie character, the drawing, is no longer covered by copyright. Now, here's a problem that that third-party users will get into. When they say, oh, well, the Steamboat Willie version is public domain, I can use it and I'm not going to suffer any consequences. There is a concept in trademark law so this isn't copyright law, which covers works of authorship. This is trademark law that covers brands and things that identify the source of goods and services. There is an argument, I haven't seen Disney make it yet, that the Steamboat Willie version of Mickey Mouse indicates Disney as the source of particular products. I haven't seen them make it yet, but it's not outside the realm of possibilities. If Disney were to make that argument, then use of the Steamboat Willie Mickey Mouse could be an infringement of trademark law. But with regard to copyright law, it is not an infringement to use the Steamboat Willie version. On the other hand, if you take the modern version of Mickey Mouse, the one where you go to the parks and you see the character walking around, the one with the big ears, round head, all that, that is still very, very much protected. Do not copy unless you have the authorization from Disney. You'll get in a lot of trouble.
Excellent. A follow-up here coming. Was that the same situation that happened with Winnie the Pooh? They're asking.
Yeah, the oldest version of Pooh is what's not covered by copyright anymore because the duration of protection expired. But modern versions, and let me also say, when I was younger, this is 45 years ago, there were newer movies that were being created of Winnie the Pooh. If you copy those newer movies, are in no way in the public domain. So if you were to go out and copy those newer movies, it's copyright infringement. You're only talking about the very, very old stuff that's, I'd say 95 to 120 years old that has fallen into the public domain. That's what's not covered. But you can't go out and start doing Pooh. There was that case where somebody created a horror movie based on Winnie the Pooh. That's more esoteric because then you're basically, the question is, well, is it fair use? Is it a parody? That's a different situation. I don't know if that's what you're talking about, but those are two different things.
Excellent. I want to see if we can get another question in here. Does copyright protection for a photograph of a functional product extend to the functional product itself, so that a copy of the functional product in the photograph would be considered an infringing derivative work?
Right. The short answer is no, but I have had people come to me in this context. I'll set the stage. I had a client, they manufactured automotive parts. The automotive parts were functional. None of them were protected by patent. None of them were protected in any way by any other type of intellectual property, trade secret, something like that. So they were selling these functional auto parts, and a third party seller, an online platform basically, had an online marketplace version, and they were selling my client's product. And rather than showing a picture of the product that they had taken themselves, they copied the photograph that was on my client's website and they put it up there. And their argument was, well, how else are we going to tell our customers what this is? Fair point. However, number one, it was an infringement of my client's copyright protection for his work of authorship in the picture. But then my client went the extra step of saying, now, wait a minute, that online platform is selling other products equally as functional, but that look almost exactly like my product. And I want them to take those products off their marketplace. And I broke the bad news to my client and I said, no, I'm sorry. Just because you have a photograph of your product, it doesn't extend to your product. It doesn't extend copyright law over your product, which is functional. I mean, that would be kind of a perversion of the law. So what ultimately happened was we got the marketplace to take down the photograph, which was clearly an infringement, but the marketplace could still sell functional things that were just in competition with my client's product.